Good evening, this is Rahul Reddy. We're live here from Houston, Texas, and every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Reddy Neumann. Emily, what do we have to discuss today?
All right, today we want to talk about the 180-day automatic extension for the H4 EAD applicants. It is a nice benefit to have if you qualify for it, but it doesn't help that many people. So we want to talk about what options you have to be able to actually benefit from the automatic 180-day
Do you have a way to
extension.
hack the system, Emily?
Potentially, we might have a way to hack the system that seems to be working. So we'll talk about that. We have our Build Back Better budget reconciliation process that's still stuck in the Senate. Supposedly the actual parliamentarian, the formal process, what they call the bird bath, is underway, and we're waiting to hear, number one, what immigration provisions were provided as part of that and whether those provisions will be allowed to move forward as the Senate puts together its version of the reconciliation bill. Now we have an update on COVID tests for travel into the United States for those people that are traveling by air. Now everyone's required to have that negative test within 24 hours of your travel into the U.S., which can be difficult depending on where you're traveling from. Maybe not everybody has the ability to get a test done within 24 hours because that's a very short window. And lastly, just dealing with consulates still with COVID shutdowns, and they're only handling emergencies. Now that we can travel, how can you get an appointment? There's such a backlog, and that just continues to grow.
Emily, first let's get to the H4 EAD, the class action suit and the settlement, and the USC has changed its policy that if you have the H4 EAD extension pending before the EAD expires, and your H4 I-94 is valid, extension is valid, you can start working. And that's where the problem is. Most of the people have filed for the H4 and EAD extension, and their spouses H1B is already approved. And so what? This particular law is not benefiting. They cannot go outside the country to get the stamping because visa is backlogged very significantly. Is there any hacking thing that you have?
So we've seen some examples of use of automatic revalidation. So we've talked about this before, where if you have a valid I-797 approval notice with an I-94, but maybe your visa stamp has expired, if you're traveling to only Canada or Mexico for less than 30 days and you do not apply for a visa, you can use your expired visa stamp plus your valid I-94 to be readmitted into the U.S. So that works for the H1B spouse who has filed the extension and already gotten it approved because they have premium processing. But what about the H4 spouse? We've seen that people have been able to travel to Mexico and come back in based on the H1B holders' new I-797 with the I-94, even though the H4 spouse doesn't have their I-797 yet, and they're both being admitted until the end date of the H1B that was extended. Now, once you have that H4 I-94 that's extended beyond your current EAD, now you can get back to work.
Let me understand this one thing. My H4 is expiring, my H4 EAD is expiring on December 25th of 2021. And I've already filed the H4 and EAD extension. My spouse H1B is extended until 2024. So if I travel to Mexico or Canada and come back before December 25th, that's when my H4 is expiring, I may get a validity until 2024. Is that right, Emily?
Right, if you show your spouse's new H1B approval.
H1B approval. And in that case, since my EAD extension is still pending, I can work for 180 days beyond the December 25th.
Correct.
Well, a couple of things that I want to caution you guys is that do not travel if your current H4 I-94 has already expired, because you may not be allowed to come back into the country at all. Second caveat that I would say is that we have seen this working in many cases, but not 100% of the time. Is there a rule that they have to give it until my spouse H1B expires? Can they only give it until December 25th sometimes?
Right, there technically is no rule that is allowing this because for automatic revalidation, each person should have their own I-94 that was issued by USCIS beyond the validity period of the visa that they are entering in. But in this case, the H4 spouse doesn't have their own I-94. But by virtue of the H1B spouse having an I-94 and they're married, the H4 should be granted. But there's no specific rule or law requiring it to be granted. So we cannot say it will work in every time. And as you said, it's very important that if you're going to do this, the travel has to occur before your current H4 expires. Otherwise, you may have no way to come back in.
And then that will be, then they have to go back, and it's not going to be good for them at all. Emily, before I move into the other topic, do you have any other suggestions on this one, though?
No, until we have visa interviews available, I think this is kind of our temporary fix that may work for some people. Otherwise, we do have additional class action lawsuit ongoing that is hopefully going to provide additional fixes for these long delayed I-539 applications. Until that happens, this is kind of our choice for now.
We have this ping pong going on between the parliamentarian, I mean, the word has been misused in the United States, who has not been elected by any of the people. What's going on? Now, we have all our provisions, at least most of the provisions that we want, passed by the House. The lot of provisions, I mean, what are the provisions that are there in the House that you want to explain, Emily?
Yeah, I think the biggest ones for employment-based are the recapture of green cards that went wasted, that hundreds of thousands of green cards over the years. That will be a huge benefit, as well as the stopping additional wastage from happening. On top of that, we have the rule that would allow you, if your priority date has been at least 2 years old, you can file the adjustment of status regardless of whether there is a visa number
and still get the green card.
Right. So those are the major provisions, I think, for employment-based.
Especially the age-out protection is also one of the things that we got. I mean, practically, if this bill, as it is passed in the House, gets passed in the Senate, Emily, the priority date for us to file the 485 will definitely be at least 2019 December, or maybe 2020, somewhere in 2020, because by the time this will be effective is May of 2022. So it will be at least May of 2020, the priority date will be for all the people. So that's a very good news for a lot of people, though. And we see the age-out kids and the backlog completely reduced for at least for a period of 10 years, which is where most of the people who have been waiting for all these years will be out of the system. They'll probably get a green card and maybe citizenship too. So that's definitely a good news for the people. Now, when it comes to the Senate, which is where the hurdles are, what's going on? Can these provisions, employment-based provisions, be passed?
Well, we know that's the problem with the Senate. We don't know what they're intending to include in their bill. And we don't even know what they've provided to the parliamentarian as part of this formal process. Have they just provided their Plan C parole option, or have they provided all of the immigration provisions that were in the House version? We just don't know, and it's like pulling teeth to get information. There's some really good reporters out there talking about this on Twitter and asking these questions to the senators. They're just not responding. They're saying, I don't know, we'll see. They're just dodging questions. It's really frustrating. And then once the Senate parliamentarian comes out with their decision, say it doesn't go in our favor, the Senate still can proceed. That's the thing. We don't know if they have the guts to actually go through with that. They've done it in the past. They could do it again. All of this needs to happen very soon, though. We're running out of time.
That's what's done by Republicans, not by the
right. Mm-hmm.
Democrats. We request all the people to urge the Congress, the senators, to have the business immigration bill. We have provided a link at the bottom of this where we have given a draft letter that we want you to contact the senators. If you have not already contacted, please do contact your senators, because this is passed in the House. And if we get this passed in the Senate, I mean, the president is ready to sign. So we have, we come very close. And immigration provision is just one of the provisions. There are a lot of other provisions in there. So it's put as a package out of the many, many pages. Ours is only like 15 pages. So if you can push this one that will be in your best interest. For all the audiences, please make all your friends, family members, and all those people who understand what problems you face should write letters to the senators. Emily, I just traveled. It's been 2 weeks of vacation or slash work. I only work less, about 8 hours when I'm on vacation. But anyway, coming to the point of the COVID test, it was 72 hours that is required for us to do it. Now they're saying 24 hours. Is it 24 hours before you get on the flight or before you get to the destination?
Good question. Yeah, it's before you can board the flight. So
because sometimes a flight takes more than 24 hours to come
right.
down.
Yeah. If you don't, right. Yeah. If you have that 24-hour flight, you have to get a test in the middle of the flight. No, luckily no, but it is problematic. I mean, this just came out, started from yesterday, and this is regardless of vaccine status. So even fully vaccinated, even with the booster, you still have to get the COVID test done within 24 hours before you can board the plane.
Luckily for people who are in India, Emily, the services that are provided there, you call the person testing guy, the testing guy will come to your home, will test it and give the results in the next 3-4 hours.
Well, that's very good.
So make sure that if anybody is traveling, the visitors, the H1Bs, H4s, US citizens, green card holders, everybody who's traveling in, that testing is done within the 24 hours, not 74 hours. So please make sure all the people are doing the test within that period of time. Visa appointments, I hear that people are making an appointment in August of 2022. That's when the booking appointment is. Is there any hacking that you have, Emily?
I don't, unfortunately. We're just seeing the consulates are just so delayed. We have people who have been stuck outside the US since March 2020 trying to get their appointments to come back. On top of that, we have people who've been stuck inside the US wanting to go home and visit their family for the last 2 years that need visa stamps as well. So when you've got all of that combined, plus consulates are still not operating 100%. It's just a big mess there, and I don't have any hacks for being able to get an earlier appointment other than once you book your appointment, going back in and requesting an emergency appointment if you think you can qualify, but those are hard to come by as well.
What we noticed is that a lot of people are doing refresh to get the proper dates. We have seen some of the dates opening up at a certain timings, which I don't know what those timings are. But you may want to use the technique of refresh and try to see if you can book an earlier appointment. And believe me, there are thousands of people who are doing that refresh and try to see. That's the only suggestion that I will, because even though the appointments are open in August or 2022, there are some times the slots will open in between. You just have to keep watching when the slots will open. That's when you have to lock yourself in. That's the only thing that I can suggest though. Emily, with regards to the COVID things now coming from Africa and more restrictions, more closures, do you think so it may benefit the employment based in the next year also? Maybe there might be spillovers next year, Emily?
That's a good question. I don't think it will be nearly the benefit that we've gotten this year and the prior year, and the reason for that is the consulates are processing immigrant visas. In the latest check-in with Charlie, he even mentioned that the consulates are processing more immigrant visas than they ever have for employment-based than they have ever have before. So that's using up some of the numbers that USCIS would normally be using. So if they're using up the employment-based numbers, that means they're also using up the family-based numbers on a pace that they normally would. We're kind of back to normal to an extent, and they have quite a backlog. They also have 2 years worth of applications to get through. So I think that they will be using up all of the available family and employment-based green cards this year. That's what my guess is at this point.
First question that I have, Emily, I need your help in it, is we know this 4-year extension of the visa stamping drop box where people's visa expired within 4 years. Now, will it revert back to 2 years starting from January 1st, Emily?
I think that's a definite possibility. Hopefully not, because of these additional travel restrictions that are coming in and this Omicron variant. I think that Hopefully the COVID flexibilities that we are seeing should be extended, but we have not heard any rumors about that one way or another.
Questions. Let's go to questions. Srini has this question from YouTube. My wife's H4 plus EAD is expiring in October of 2022. Can I apply for the extension right now? Assuming, Srini, if your H1B is already extended though, I would file the H4 plus EAD extension, even though the rule stipulates that you cannot file within 180 days. We have done it several times. Not a single time we ever got the denial. Not anybody else has ever reported. We do have a YouTube, we do have a Facebook, we do have the TV Asia that nobody has reported a EAD getting denied though. Now, in case though, if your H1B is not already extended, either you transfer the application or amendment plus extension, amendment plus extension may be a good idea, Emily, for them, because what if your salary might have risen $5 per year? Can you file an amendment? Yes, you can file an amendment plus extension. So in that case, if your H1B is expiring in October 2022, if you have some increase in the salary, some minor changes in your job duties, your company has an authority to file an amendment plus extension. Now that gives a higher chance for you, your spouse, to actually get an EAD and H4 way earlier than what they are supposed to get.
Morelli has an EB3 downgrade and 485 that was filed in November 2020, still no biometrics appointment, and wants to know, is there a way to get it done? So my first suggestion would be to use the chat Emma through your MyUSCIS account to see if you can get things moving from there. Your other option would be to try a walk-in appointment. Not every application support center is able to accommodate walk-ins, but some of them will. So it doesn't hurt anything to try to just show up and see if they'll take your biometrics that way.
Questions from Archie Americas. How long the premium processing for the I-140 takes? Assuming that, in Nebraska is asking, assuming that this is a direct filing of the I-140, it's taking about 3 to 5 weeks right for now for the premium processing to be processed by the Nebraska Service Center.
Sukarna wants to know, can an employer revoke an I-140 after the 485 is filed? EAD is already approved, but it's not been 180 days yet. Well, technically, yes, an employer can withdraw an I-140 at any time. They don't have to wait a set number of days before they can do that. Now, the 180 days is important because that determines what happens to your case after the employer requests a withdrawal. So if a withdrawal is requested before your 485 has been pending for 180 days, you don't qualify for AC-21 benefits. That 485 could ultimately be denied. If it's after the 180-day mark, the employer can still withdraw the I-140, but that I-140 withdrawal will not impact your pending 485. Your 485 can be taken with you to a new employer under AC-21 as long as the job offer is similar.
Question from Natural Yogi. Birth certificate RFE, it's a late registration. They're asking the non-availability of the birth certificate. No, do not provide that. You can't have a birth certificate and a non-availability certificate, even though they're asking as an alternative thing. I want you to provide the other alternative things, not just be satisfied with 2 additional affidavits. I want you to submit if you have Aadhaar card, you have a PAN card, you have ration card, you have election card, you have school records, you have medical records, you do have birth certificate from the hospital, any records that have the birth date or your name sometimes, even birth year, for example, in the election card, I think so you only get the year of the, not the date of birth. So all those things try to provide as much as possible, but definitely do not request a non-availability certificate, do not provide a non-availability certificate, because you have a birth certificate. Once you have the birth certificate, you cannot have a non-availability certificate.
Rod's interfiled from EB3 to EB2 and wants to know, does the AC-21 clock reset, and is there any way to follow up after the interfiling with the Nebraska Service Center? As far as AC-21 clock resetting, We're not aware of any guidance from USCIS about that, but we do have a practice pointer put out by the American Immigration Lawyers Association that does suggest that that clock resets and you need to wait 180 days after interfiling before you change jobs using AC-21. But how do you know when your interfiling is actually done? Can you rely on your tracking confirmation to show when it was delivered? Or do you have to wait for some kind of confirmation that it's actually been received and processed? No one knows. And there is no way to follow up. There's no email address to contact. You can call the 1-800 customer service center, but it's impossible to speak to a live person that way. You can try chatting with Emma in your USCIS account to see if they're able to provide an update. Otherwise, you may have to work with your congressman or senator's office to see if they can update you whether it has actually been converted to EB3, from EB3 to EB2.
Niranjan from Facebook has this question. His passport stamping has expired. He has his valid 797. Can he go to India and come back without getting the stamping? The answer is clearly no. N-O, no. You cannot come back if your passport has expired from India to here. That exception to come back with the valid 797 is only valid if you go to Mexico or Canada and you're not going for stamping, you're coming back within 30 days. Now, having said that, can you travel from Mexico or Canada to India and come back to Mexico or Canada and come back? The answer is no. It's only if you're traveling to Canada and Mexico, not if you're traveling to India.
Sam wants to know, does the National Benefit Center accept interfiled medicals? Where do we send it? What documents need to be sent? Yes, they do. We're not seeing them rejecting any packages that are being sent to them. As far as how to do that, we do have an article on rnlawgroup.com. Once you go to our website, in the search, you can put in medical exam interfile, and it gives you all the details for how you can accomplish that.
Srinath Reddy, can we start a service-based LLC with a H1B visa? You cannot start the service-based LLC though, because you will be considered to be working. Now, there are some exceptions available if you're just owner of the company and not involved in the company. But before you do, I strongly recommend you consult a lawyer though, because if any involvement of you is not good at all to be in a service-based company. If you're owning a stock like Microsoft or something like that, that's fine. I mean, there's nothing wrong with it. You may be already having a 401k, that's fine. But if it's something, a small company where it's a service-based, before you do any of that activity, you need to consult a lawyer.
Jason has a priority date in 2013, filed the downgrade from EB2 to EB3 in October 2020, started using the EAD, working for the same company. Wants to know, if EB2 becomes current, can I go out of the US, come back with the H1B stamp, and refile using EB2? Yes, you do need to get back into your non-immigrant status in order to file a second I-485 application. And the way to do that is to have a valid H1B approval notice and a valid H1B visa stamp by traveling, coming back in. Once you get your new I-94, putting you back in H1B status, then you can file a second 485.
Can my son apply for Social Security number? And he just got a GC EAD along with mine, and he's 13 years old. Absolutely he can. It will not be considered that your child is married to the adjustment of status by getting a SSN. I want you to refer back to 1 year ago video, what the marriage to the AOS, if you want to understand what the marriage is. It's not a real marriage, it is whether or not you're using the 485 instead of non-immigrant visa. Yeah, if I were get your child, yeah, get the child Social Security, absolutely not a problem.
Ram has a question for you. I think we've done this in the past. He has filed the EB3 485 with one employer. Now he's with another employer and just got an EB2 I-140 approved. Can he interfile the EB2 I-140 even though it's with a different employer?
He can file the interfiling thing, but you may want to look into whether you want to interfile or you want to refile the entire 485 application. We want you to watch the video that we posted about a month ago, interfiling versus refiling 485 application. The past 1 month, 1.5 months, we covered this several times. Just look into it. To answer the question, definitely you can, but you may want to consider refiling the entire application. Karthikeyan from Sinapan from YouTube has this question. He got 693 courtesy letter from the USCIS planning to send the medicals. Can you mail it to the PO box mentioned in the letter? Absolutely you can. You can, you should. That's the best approach. Emily, also, we have received several courtesy letters for the people who already have the green card approved. Some of them have submitted the medicals, some of them did not submit the medicals. I'm telling everybody submit the medicals, even though they got the green card. I think so. It's based on the conditional that they're going to send the medicals they already approved. I got like 3 courtesy letters, and I'm telling them submit them the RFE, the courtesy letter. Submit the medicals when they ask it. Submit it. That's in your best interest. A lot of people are asking the predictions of how the priority date moves, Emily. Any projections on EB2s?
Okay, so we know from the check-in with Charlie that the consulates are using more employment-based green cards than they have in the past. We also know that he pushed EB2 forward more aggressively as a way to try to figure out how much demand there's going to be from people switching from EB3 into EB2. And so he's indicated that that forward movement is going to slow down for the next couple of months. Then they're going to reassess how many people actually converted into EB2 or refiled in EB2. And then we may see an additional forward aggressive movement in EB2 in April 2022, but not before that. That's about all the information we have. In addition, the rest of world applicants in EB3, they're using a lot of those. EB2, rest of world is using more than they normally would, which means there's going to be less spill across from the rest of world to EB2 and EB3 India. So we may be seeing fewer that are able to get approved this year.
Chimarachurla Kishore from Facebook has this question. My place of birth is different in passport and birth certificate. Will that be an issue? Mr. Kishore, we have noticed that normally place of birth in the passport has not been reflecting properly though. We do not look into that at all, the passport data, place of birth. We haven't seen USCIS pointing out to the passport about the birth certificate. We haven't seen any problems because passport has a different place of birth. We haven't seen that as a problem.
Love to Learn says, if we file a new EB2 I-485 with an approved I-140, what's the probability that it doesn't go to the Texas Service Center? Do we see any chance of improvement in the Texas Service Center? So based on what we're seeing, the majority of the standalone 485s filed based on an approved I-140 and employment-based are going to the National Benefit Center. We're getting the receipt notices from the National Benefit Center. We are also seeing shortly after that, the cases are being transferred to the Service Center where the other application is pending. So there's no guarantee that just because you got the receipt from the National Benefit Center that the case will stay there. USCIS can move these around wherever they want to. We are seeing some people that it's being transferred to Texas, even though it was filed and accepted at the National Benefit Center.
Nayaz is asking that if the H4 and EAD is pending though, can they continue working after the EAD is after the H4 is expired because pending the EAD for the H4 EAD? No, the answer is no. The settlement is a little bit different than what you're thinking. Only if the valid I-94 is been extended and the EAD is not extended, they can work. But in your case, it's May 2022, the H4 plus EAD is expiring. If it's still pending, he or she cannot continue after May of 2022. You may watch the first part of the video in the first 10 minutes. We've discussed about hacking system, going to Mexico and Canada. That is a better way that you can try that if you want to.
Venkat wants to know, by what date does the Senate need to take a final decision on this budget bill to see if the employment-based provisions are included or not? Well, technically, they have a 2-year window. The entire 2 years of this election cycle the Senate has in order to act. However, next year is an election year, which means they're not going to do anything that remotely touches immigration. They don't want to touch it with a 10-foot pole because it might mess up their ability to get reelected. So anything practically that you need to get passed has to happen by December 31st.
Okay, are you guys taking the H4EAD litigation? No, we are not, because we filed a class action suit, so that's everybody's already included in it. So the results of the regular cases that we're filing in the H4EAD, they're dodging things. It's not working out very good. So we stopped accepting the H4EAD litigation.
Primnanth, how to know if the medical was actually added to the file? Tried a FOIA request, but I don't see it. What's the next step? Really, the only way to know is to see if you can chat with Emma to see if she can confirm that it's been added to the file, or seek help from your congressional assistance there. But that is the difficulty with interfiling. And the same thing with the interfiling to get into EB2. There is no process to confirm when it's actually done.
Crash Patel has this question. My wife and I am both an independent H1Bs. When the priority date becomes current, does my wife has to change to H4 to file the 485? Absolutely not required. She can be an independent H4. She must be married and living together with you. That's all. She can have a different H4, not a problem.
Sarang wants to know what to expect from the Tier 2 officer when they call you back about a out of processing time for I-131 and I-765. Our experience is they call you back and just tell you that your case is in line for adjudication. We'll get to it when we get to it. We can't give you a time frame. So you may at that point need to try to make an expedite request to see if they will take that if you meet some of the expedite criteria. But the actual customer service is very lacking from USCIS right now. They give you zero information.
Mayur has this question. If my file has been moved from National Benefit Center to Texas Service Center, is there anything you can do to get it processed in a proper timing? No, Mayur, I do not have any method to do it. But if your EAD has been pending and not been approved, we strongly recommend to contact Stephen Brown if it's been pending for more than 8 months or 9 months. In the adjustment of status EAD though, not H4 EAD, you can contact Stephen Brown in our office. We may be able to go to the litigation process for the 485.
Santosh says, it's been 4 weeks since my 485 application was delivered by FedEx. Still no receipt notice. Check still isn't cashed. Emailed the lockbox support. No response. Yes, that is the frustration that a lot of us are seeing. We've been having this problem going all the way back to October 2020, and there's really not anything you can do other than look through the application to see if there's anything in there that could have possibly caused it to be rejected, and if you find something, refile it if the filing date is still available to you.
It's taking 2 months right now. In general, we have noticed that it's taking 2 months. The cases that have been filed 65 days ago, Emily, are getting receipt notices. And it is really frustrating for our clients. It's really frustrating, listening to them, and then they creating all kinds of things. I understand your lawyer might be a good person. We don't have any doubt about it. But yeah, it is common problem that we notice that it's taking 60 days now just to get the receipt notices or have your check cashed. And we do check every day the check cash to see and try to report to the clients that the check has been cashed.
Yeah, and I don't think I've ever gotten an email response back from that lockbox support email address.
Boo, they don't. Vinod has this question from Facebook. Can a H4 go to Mexico and get a new I-94 with an expired H4 visa? Now, there is 2 different things here. Does your wife has a valid H4 I-94 Now, sometimes the visa might be expired, but she may have got a previous extension. So if she has a valid 797, okay, even though visa expired, she can. But if she doesn't have the valid 797 though, do not. So in the case where, let's say for example, my passport visa expired in 2020 December, and my I-94 of the H4 is expiring in 25th December, then I can go to Mexico and come back. But if my passport visa has expired in October of 2021, and my I-94 also expired in October of 2021, and my extension is pending, do not go to Mexico. You may not be. Most probably, you will not be able to come back. Do not go to Mexico in that situation.
Shanaz has an I-140 approval with a previous employer and is getting ready to file perm with the new employer and wants to know what happens if the previous company shuts down. Well, once that I-140 is approved, you get to keep that priority date regardless, unless that I-140 is revoked due to fraud or misrepresentation. So assuming that's not the case, even if the company later shuts down, that I-140 priority date is yours and you can port it to your new I-140.
Manjushree is asking if your office works on H4 to F1 visas. Unfortunately, we don't do it, but there are other lawyers who will be willing to help you out in H4 to F1 visas though. Jay from YouTube has this question. B2 to H4 change of status advisable at this time? Yeah, I mean, if you are eligible for H4, absolutely, B2 to H4 is advisable. Questions with regards to the green card has been approved, how long it's taking nowadays for the actual green card to arrive. Anywhere between 2 weeks to about 6 weeks is the average time it's taking for the green card to be arrived.
Barath has the H1 approved, but the spouse's H4 is pending. I-94 and H4 EAD are expiring in February and wants to know if the automatic revalidation doesn't happen, what happens to the current I-539 application? So assuming that you mean when you come back in, they only give the I-94 to February, which is when the current I-94 expires, that I-539 application continues to be processed. So that will continue. The only difference is that your I-94 number will change, but the 539 application and the EAD application will continue to be processed.
Good question is coming from Reddy Neumann. My I-140 is approved, I-485, 765, 131 is pending, H1B expiring soon. Am I eligible to work until I get the EAD or I-485 approved? Since this is your first EAD applications under the 485, you are not eligible to work after your H1B expires. So if you did not get an EAD, you should file for the H1B extension.
Karthik has an EAD that was approved, but USPS lost the package. Filed the application for a replacement card, waiting for the card. Status of the case is still received. Yes, we do see that happen quite often, and they're taking months to issue a duplicate card. So you may need to try to contact USCIS through their 1-800 number and request an expedite due to USCIS error, since the card was lost through no fault of your own, to see if they may expedite that reprinting of the card.
Shanaz has this question, can we do the H4 extension, EAD extension, and this is the first time the person has applied? This is the first time person is applying for the EAD. No, this is only, what we spoke is only about the EAD extensions though. If it's a first time EAD, then the provisions what we told are not applicable to you, Shanaj. Kishore Reddy has this question from YouTube. EB1, May 2021, prior to date. When can I expect my green card? If your final action, if you have already filed the 485, hopefully so, you, depending on which service center, if it's a Texas service center, it's a very long period of time. Yeah, it could be approved any time, but it may take up to 4 or 5 years for you to get the green card, though, because that's how the processing time is right now.
I've seen a couple of questions where a person has their first 485 pending, received the EAD and AP, they file a second 485 and want to know if they want to change employers after 180 days, can they use the first EAD to do that? Or can they travel and use the first AP to travel? We're kind of in uncharted territory here. There's no guidance from USCIS about that. I think that the purpose of an EAD and an AP are tied to a pending I-485. I don't think it's necessarily tied to a particular 485, but there's just no answer to that question, at least coming from USCIS on that. I think that you would have a reasonable argument that that EAD should be valid because you have a pending 485, but the only way to find out is to try it.
USAs need to improve their process. This is a suggestion from our they definitely have to improve their process. There are many suggestions that we have suggested, and you can suggest it too. There are some things that they're just unnecessarily complicating the issues. For example, they can take out a lot of different things that they put it on, like interviewing the 485, and especially then they did the fingerprinting for the H4s, which they later on retracted some of those things, but they need to still do a lot of the things that are not needed in the process, especially to use the extra 140,000 or 150,000 green cards that we got this year. That should be used. So hopefully, they will work on some of the improvements. Emily, with Charlie being now retiring, do you see any changes once the new person comes in?
Well, it's a bit ridiculous. His last day was December 3rd. We still don't even know who's replacing him. And he was supposedly going to help this person get ready with the January visa bulletin. And this person is probably going to be trained by Charlie. So I don't have high hopes that it's going to change much because they'll be trained by him in the same way.
Yeah, and those people who are in the administration itself in a very higher ranking will get up the promotion. We have a civil services system in some of the common law countries, Emily, where normally the outside people come and head the departments, though. They bring in new perspectives, though. In USA, though, what happens is that the person who's been working in the same department is climbing up the ranks, and then they just use the same system. They never try to improve, which is what frustrates here, is that they just go with the same things again and again. Definitely, there needs to be a lot of improvement on it. I mean, if they're not doing their job, they should get fired. I mean, that's simple. But we'll see as things come in. We have put a lot of pressure on the USCIS. The USCIS did respond to us. USCIS State Department also responded to us. At least they acknowledged the emails that we drafted and gave it to you. So when the new person comes in, we'll see how they will, and then we'll draft letters at that time as and when needed, and we'll provide it to you.
Suraj from YouTube has filed the 485, 765, 131, I-140 in March of this year. The I-140 has already been approved, but still no EAD. Of course, the 485 is still pending with an H1B that's set to expire next year, and wants to know how long might it take for the 485 to be approved. They're processing at the Texas Service Center only $1,300 a month on average. And because of the number they have pending, it's going to take possibly years for them to get through the already pending application. So I don't have high hopes that it's going to be in the near future. Hopefully it would be before September 30th, 2022, so we can use up all these green cards. But you may have to file an H1B extension if you don't get your EAD in time. And you can hold off. The good thing about the H1B extension is as long as it's timely filed, it automatically extends your ability to work for up to 240 days while it's pending. So you could technically wait until the last minute. And if you still don't have the EAD, still don't have the green card, and it doesn't look like it's getting approved in time, file the H1B extension at the last minute to get that extra 240 days.
Vijay's priority date is September 2014 under EB2. When can he file the 485? It depends on how many green cards they will process this year. It also depends on how many green cards, family green cards, will be wasted this year, because that will fall into next year. So it's going to be very hard to predict though. And of course, there is a lot of legislation pending. I can assure you, Vijay, one thing though, that if the Senate passes the bill though, for sure your priority date will be current within 1 year. Absolutely, I'm sure about it. But if that doesn't go through, if the Senate bill doesn't go through as it's passed in the House, I cannot tell. It could be 1 year, it could be 30 years or 40 years. I mean, that's a lot of variation. It could be 1 to 40 years. Now think of that. But if the Senate bill passes through with the provisions what the House passed through, I can guarantee you the day the bill goes into effect, your priority date, you can file the 485 application. Am I right, Emily? With a priority date of 2014?
Yeah.
Absolutely, I guarantee you. The day it becomes effective, as it is written in it, you will be able to file the 485 and EAD.
Samuel wants to know how long the case review takes after the employment-based green card interview. Is there a timeline, like 120 days or 180 days? That's the frustrating part about I-485 applications. There is no set required timeline. USCIS can take its sweet time in the interest of national security. They have the discretion to take as long as they want to. So even if it's 180 days after your interview and your priority date is still current, you can't really force them to issue that approval. There's no outside normal processing time. A lot of it is when you go in for the interview, the officer may not have actually reviewed your application yet, so they complete the interview and then later they'll go back and review everything and make sure that you're eligible for approval, but there's no timeline for them to do that. So it could be a few weeks, it could be a few months, it could be longer, unfortunately.
Arsu from YouTube asks, my priority date is February 2015 in EB3. Should I initiate EB2 or should I wait for the bill to pass? I will not wait for the bill to pass. I would like to have both options available, EB3 and EB2. Since your labor certification is done under EB3, I would definitely, if possible, initiate the EB2.
Kishore's wife is on L2 and her I-94 expires today. His L1 and L2 extension are pending and wants to know when can she start working again. Is it when my L1 is approved or does she need to wait until the L2 is approved? She does not have the L2 EAD either. So let me first say that the settlement agreement regarding L2s is not effective yet. And the reason for that is CBP and USCIS need to change the wording on the I-94 to denote that you're an L2 spouse, not just an L2. So until that happens, which is supposed to be within 120 days of the settlement, there is no automatic work authorization for L2s. She still needs an EAD. So that being said, she can't start working based on your L1A being approved because she needs to actually be in L2 status. So she needs her L2 to be approved. If by the time her L2 gets approved, they've implemented that settlement agreement and it comes with an I-94 that says L2 spouse, then she will be able to work based on the L2 approval without having to file for an EAD separately.
Raj has a suggestion that the visa brokers in Hyderabad can get an emergency appointment. The refresh doesn't work. My advice to the people is no, don't use the visa brokers to get the emergency appointment. Absolutely not. Because any statements they are making on your behalf will be used against you at a later date. If they're making any wrong statements, you are bound by it, and at a later date, it will come to haunt you. So definitely, you need to know what statements they're making. If you don't know, don't use them. I mean, you can't use the false statements to get an emergency appointment. You may get the emergency appointment, you may get a visa, but at a later date, they will haunt you. Any wrong statements will haunt you.
Devitha applied for her L1A extension, received an RFE. That RFE has been replied to and wants to know how long it takes to be adjudicated. It's been almost 10 calendar days. So for premium processing, once USCIS receives the response to the RFE, then it's 15 days that they have to issue a decision or issue a refund of the premium processing fee. So you've got about 5 more days to wait.
Shivani has this question. Can you predict the priority date February 2021 to be current for India? Shivani, assuming that the COVID disappears, assuming that no new law comes into the picture though, it's going to take about 100 years for you to get the green card. I hope you will live by that time. The suggestion that I normally make people is that if you want to live in the North American continent, maybe you should apply for the green card in Canada, which we do not represent, but I'm just telling you that is a better option. If the things remain as they are without change in the law and no COVID effect, you may never get the green card. 100 years is too long for you. So that's our projection.
Kareem wants to know what's the processing time for an I-290B for a denied H-1B. I would say 6 to 8 months minimum. It can go up to a year, even longer. Depends on whether that I-290B was filed as an appeal to the AAO or was it a motion to reopen or reconsider that's done by the service center. Both of them have their separate processing times. But they're not a fast process. There's not a way to expedite them. There's no premium processing. Unfortunately, you just have to wait it out.
Some misunderstandings for Meeraj about the Dropbox. I'm sorry, this is from Shashikant, Akula. The Dropbox, you will be eligible even if you change the employer. There's no rule that when you go for the Dropbox, it has to be with the same employer. It could be from a different employer. It's perfectly okay.
Meeraj wants to know about litigation for long pending 485 applications in EAD and AP. So for the 485, litigation is very difficult to be successful unless it's extremely like 3, 4, 5 years that it's been pending and the priority date is current. Anything less than that is considered reasonable, and the courts don't really have jurisdiction to force USCIS to adjudicate a 485 because it's a discretionary process. There's nothing requiring USCIS to do it. As far as the EAD and AP application, the interim benefits that you might receive based on the pending 485, litigation can be successful in speeding up those. Because you need to get those in a reasonable period of time. The whole purpose of it is so that you can work and travel while your 485 is pending. So they should be giving you those in a reasonable time. So litigation is an option for that.
Kiran Kura has this question. My spouse got a H1B first time in 2012. She used it for 14 months and she's on H4. Now she wants to move to H1B and the employer is telling she cannot reinstate because it's more than 6 years. That is a wrong statement by your employer, Kiran. Your wife can move to H1. There is no limit of 6 years. She must have had been counted towards the H1B in her lifetime. She's been counted because she used the H1B. She worked on H1B for 14 months. The only caveat is that when she gets a H1B without subject to cap, she cannot get the entire 6 years of H1B. It will be only 4 years and 10 months because that's the amount of time that is left over in the 6-year period that she has. And if you want our office to represent, you can contact our office. We would be able to help your employer to file the H1B for your wife. Absolutely not a problem. Suresh from YouTube has this question. What happens for the age frozen kid when his 21st birthday? Well, you already know freezing of the age. That's good. You watched, you're very knowledgeable. That's very good. Once to froze the age though, I just want to give the details is that the I-140 must be approved. The final action date has to be current and the 485 has been filed and the child has to be under 21 under the CSPA age. All 4 has to happen at the same time. One cannot happen one time, one cannot happen. If the age is frozen though, once the child becomes 21, the child can continue receiving the benefits of the 485 application pending, like the EAD and advanced parole, and they continue to be in the adjustment of status until you get the green card.
Kirti, her parents have a visa that's valid until May of 2022. And since there's no slots available to apply for a new visa, wants to know, can they travel to the US and leave before the visa expires? So the visa stamp that's in the passport has to be valid on the day you're entering into the US. And then once you're in the US, it is CBP that determines how long you can stay based on the I-94 that they issue. So if they're able to be admitted, I'm assuming this is a visitor visa, so they're admitted in B2 status based on the fact that on the day they're entering, they have a valid B2 visa in their passport, then it's up to CBP to say how long they can stay, and they just need to leave by that date.
The question that comes here is that my parents have the visa validity until May 2022. Can they come into United States and leave Canada before the visa?
Oh, that's the one I just answered.
Oh, sorry, I didn't pay attention. Sorry.
Let's see. Trekkerin applied for the 485 in October 2020. Still no GCEAD. Texas Service Center is simply giving a standard response to service requests. What additional review are they doing? We don't know what the Texas Service Center is doing. What we do know is they have thousands and thousands and thousands of applications pending from before October 9th, 2020, and they're only processing about 1,300 a month. They're delaying everything. You're definitely not alone in not getting your green card EAD yet, and that is something that litigation may help with.
Nirav has this question that he's changing from location A to location B. Does he need to file the labor and I-140? Nirav, it depends on if it's a consulting company, especially if it's a consulting company though. In the labor certification, they always put it as that you could be working at unanticipated location. 99% or any lawyer who has done the labor certification do put it if it's a consulting company though. So in that case, you absolutely do not need to file a labor and I-140 again. But if that's not the case though, there are some provisions that allow you not filing, but I would rather recommend that you contact a lawyer privately. If your company is not a consulting company and you're moving from A to B, what are the consequences? I would recommend to consult a lawyer. There are ways to avoid it. There are ways that you have to file it. It's better to consult a lawyer if it's not a consulting company.
All right, well, I think we're out of time for today. Thanks so much for joining us. We'll be back again next week at 5 o'clock on YouTube and Facebook. And you can always subscribe to our newsletter at rnlawgroup.com so you get the updates every Wednesday straight to your inbox.
Thank you guys for tuning in.